It's a medical malpractice case. I'm giving opening remarks. And now, after I finish opening remarks after half an hour, the judge turns to me and says, Mr. Oginski, I'm dismissing your case. Can the judge do that after I make opening remarks before the defense even stands up to make his opening remarks? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now when I get up to make opening arguments, I have to make out what's known as a prima facie case. I have to show that we are more likely right than wrong, that number one, there was wrongdoing, number two, the wrongdoing caused injury, and number three, that the injury is significant and permanent. I have to show to the jury that there are certain elements of this case that we are going to prove to them during the course of this trial. And if I fail to make out what's known legally as a prima facie case, which contains all the elements of liability, causation, and damages, the judge has every legal right to dismiss my case before any testimony is ever taken, before the defense attorney ever stands up to make his opening argument. Now, how often does that happen? The reality is that in a civil lawsuit in New York involving medical malpractice, it does not happen very often. But there are some instances, it's very rare, where an attorney gets up to make his opening remarks, his opening arguments, and fails to lay bare his proof, fails to tell the jury, fails to tell the court about all the elements of liability, where there's wrongdoing, where the causation is, where's the link between the wrongdoing and the injury, and the extent of the injuries that this injured victim sustained. And if the attorney doesn't do that, the judge on his own, without any prompting from the defense attorney, can turn around and dismiss the plaintiff's case, all because he has failed to make out a case on opening arguments. Typically what will happen is that the defense attorney will stand up after I am done making my opening remarks, and he will likely say, Your Honor, I move to dismiss Mr. Oginski's case because he failed to make out a prima facie case on opening argument. And the judge will likely turn around and say, motion denied. Counselor, make your opening remarks. And now the defense attorney has to decide whether to go ahead and make his opening remarks because there's no legal requirement for him to do so. But in most medical malpractice cases, you will find that the defense attorney is going to take advantage of that opportunity and give his opening remarks. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice trial here in the state of New York. You know, I recognize you're watching this because you likely have questions or concerns about your own particular matter. Well, if you're thinking about bringing a lawsuit and your matter did happen here in New York and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Jerry Oginski. Have a wonderful day.